want to add that I would want to add for this session is not just how do we do it, but why is it important? I think there's still a lot of myth and misunderstanding for fathers around non-marital births, particularly around how and why is it important for them to establish parentage, and what does it mean to be in a legal relationship with your child, that, oh, I can't just access their healthcare records or their school records or whatever role that a parent would normally be in. I think that's still really in our culture. So we're really excited to have folks come into a conversation with you all about what does that look like? How does it work? And then, what can we all do collectively to help people understand the process? And we always have a mix of dads and providers in the room. So there may be folks who have direct experience with the system that may have questions or bring experiences into the chat. We won't be able to answer specific questions about your case, but there may be ways in the chat that folks might be able to connect you to someone who might be able to help you. So from the perspective of the Washington Fatherhood Council, we are guided by the research and the evidence, and the research tells us, and the evidence tells us, and dads tell us that child and family outcomes are improved when fathers are involved in their kiddos' lives in a loving, guiding, nurturing way. And that isn't necessarily the way our systems are set up. That isn't necessarily how we all have thought about family parental roles. And so it's really important for us to lean on the science around the unique role that father figures and father-like parenting plays in child development and wellness and family stress and family well-being. Moms do better, dads do better, kids do better when it's a peaceful, loving relationship between those caregivers and in that role. And to get to that, we know from the work that we've done as a council and the current work that we're doing with the Washington State Fatherhood State of the State study, that we have a dearth of resources for fathers, and that fathers should have those supports to become the dads that they aspire to be. So it's not a simple matter of, well, let's just set up some services and everything will be fine. There are systems issues that we need to have candid conversations about, and there is capacity that we need to recognize is lacking. But to get to that, we all need to become allies. So to the service of children and families. So thank you to DSHS always for supporting this council and the staff that make this possible. Thank you to Dieter Jacobs, our heavy lifter around making this possible. You'll be hearing from him in the chat on and off across the morning. And thank you to the Department of Health, who provides a grant that pays for these series, and we have just re-upped with them for another year. So we're excited to say we'll be back, and we will continue in 2024 beyond today, because we have folks who really understand the need for us to be in this dialogue. So I'm going to, and then you just heard that Dieter turned on the recording. So please monitor your comments. Likewise, you're being recorded. And it will be posted, the recording and the slides will be posted on our website within a couple of days. So if you had folks that you thought were going to be here from your team, or people that you'd like to share it with, please send it to them. Have a lunch conversation with this recording with your team. Spread the word, because you all are now allies. And so it's your opportunity to share that with other folks. And the last thing I would ask is, could you please introduce yourself in chat so we all know who's here? We won't obviously do an introduction live, but if you could let us know what brings you to this table in relationship to fathers and father inclusion, access, and equity, that would be fantastic. If you're a dad, let us know that. But there is a dirty word in our world, which is just a dad. There is no such thing. So please refrain from saying I'm just a dad, because you are so much in the lives of your children and your families that the just word just doesn't work. So I will turn it over to Sarah. I believe you're going to start, right? Is that correct?
Sure, I can get started.
Okay, great. So I'm going to turn it over to Sarah Jackson, who is one of our allies on the council and has been an incredible um, addition to the conversation around the perspective of the prosecutor's office. So she has a wealth of information and experience and wisdom around this process and the role of the prosecutor as it's evolved around this process through the King County Prosecutor's Office. So Sarah, I'm going to turn it over to you, and then Jill and Bridget, as you start, if you could introduce yourselves a bit and give us the context for your remarks, that would be great.
Thanks, Anne. As you mentioned, I'm Sarah Jackson, and I am a deputy prosecuting attorney with the King County Prosecutor's Office. And I have been with this office for 17 years now, might be going into year 18, I'm not even sure, maybe 18 years. And I started in our criminal division, went to our civil division, and I'm now in our family support division. So we represent the Division of Child Support in a number of family law matters, one of them being parentage cases. So I'll be going over today kind of a prosecutor's perspective on how parentage works in our office. The first thing we're going to go over is the change from paternity to parentage. It historically had been paternity cases, which dealt with the legal relationship between a father and child. And that term has now changed to parentage. So most of the laws that we work under come from the Uniform Parentage Act, and that was created in 1973. And at that time, it was referred to as paternity. But as times have changed and families have changed, so has our language and our words and the intent to make it more inclusive of all families. So in about 2017, the Act made a number of changes, and one of those was a change to the term parent, to the word parentage. And the hope is that that will then allow it to include all different families, and that parents could be two mothers, two fathers, a mother and father, and rather than it being only paternity. So the intent of it is to make sure that all families in all of their forms are included in this act. So I'm sorry, I will do my best to use the term parentage because that is the current term. Sometimes I revert back to the old language, but we will do our best to use the current term and the correct language to ensure that all people are included and all forms of families are included in this presentation. I'm now going to pass it over
Hi,
to, hi.
this is Bridget Pierce. I am with the Division of Child Support, Parentage, and Paternity Program. I have worked for Division of Child Support for about 15 years now, a little more than that. I started in 2008, so I have a lot of experience with Division of Child Support. And I have been a parentage coordinator in a local field office for about 6 years before I transitioned into the Parentage and Paternity Program statewide, where I've been for a little over 2 years now. So I'm going to talk a little bit about ways to establish parentage, and then I'm going to hand it off to Jill here in a moment. But there are 3 ways to legally establish parentage: marriage, court order, or acknowledgement. Marriage includes both children born during a marriage or within 300 days after the termination of a marriage. So that would be a child that's conceived during the marriage but born after a divorce. Parentage can also be established by court order. However, as we all know, the court process can be difficult and expensive and often takes a long time. The acknowledgement of parentage is a faster and less expensive option for establishing parentage administratively outside the court system. The acknowledgement form that's used in Washington is maintained by and filed with the Department of Health. We'll cover each of these processes in more detail during this presentation. Jill and I are going to discuss the marital presumption and acknowledgement processes, and then we'll be handing it back to Sarah to address the court order process, specifically her process in King County. There are many benefits to children and families that come with parentage establishment. Children know who their parents are. They have access to family medical history, rights to Social Security and veterans benefits, access to medical and life insurance from their parents, emotional and financial support from both parents, and legal parents have rights to petition the court for custody or visitation. If parents are not married and the father or second parent doesn't sign an acknowledgement of parentage in the hospital, the birth certificate is initially listing the father or second parent as none named. When DCS gets a case with no father or second parent named on the birth record, DCS does pursue parentage establishment. The legal presumption of parentage means that if a birth parent is married at the time a child is born, their spouse is presumed to be a legal parent of the child. Additionally, an ex-spouse is legally presumed to be a parent if the child is born within 300 days after the termination of the marriage, and parentage was not otherwise addressed in court as a part of the dissolution. If a spouse is pregnant while a dissolution or divorce is happening, the legal parental relationship between the spouse and the unborn child can be addressed in the divorce decree. So either it can be affirmed that this person is a parent of the child, or parentage can be disestablished in the divorce. If parents are married after the child is born, a marital presumption may be created in 3 ways. This is unusual, but it is legally possible under the new Uniform Parentage Act. The spouse can file an assertion of parentage with the State Registrar of Vital Statistics. That means filing a form with the Department of Health. The spouse agreed to and is named as a parent on the child's birth record, or the spouse resided in the same household with the child for the first 4 years of the child's life, and that person has openly held out the child as their child. So moving on to talk about the acknowledgement of parentage. There has been a long, successful parentage and paternity program in the state of Washington. 30 years ago, the courts were jammed with paternity actions as the out-of-wedlock birth rate went up. As you're probably aware, court actions are expensive and can be slow. All states are now required by federal regulation to have a process for voluntary acknowledgement of parentage. This option creates an alternative avenue for families to voluntarily establish parentage that is less expensive and more accessible than going through the court system. Diverting these processes from the courts also takes many actions off the court docket, freeing them up for others who need access to the family court system. So if parents are in agreement, they don't need to take time and space and et cetera out of the courts. In 1989, when the partnership between DCS and DOH was formed, there had been about 2,000 paternity affidavits filed per year. In the first year of the partnership between DCS and DOH in 1990, that number more than doubled to about 4,500 filed, and it has grown steadily ever since. Over 23,000 acknowledgments of parentage were filed in 2022, saving many families the time and expense of going to court. In 2022, for over 90% of children that were born to unmarried parents in Washington state, parentage was established using the voluntary acknowledgement process. Over 80% of those acknowledgments were signed at the hospital at the time of the child's birth, meaning the process was free to the families who did not need to pay a filing fee. If the families who established using the AOP process came to DCS for help establishing parentage in court instead, it would cost Washington taxpayers millions of dollars each year in court costs. It's estimated that this administrative parentage program saves taxpayers well over $13 million per year in attorney's fees by diverting these families from the court process. The acknowledgement of parentage is a legal form that may be downloaded from the Department of Health website and is used to establish a parent-child relationship and add a second parent to the birth certificate. An acknowledgement form can only be used if everyone agrees and if no other person claims to be a parent of the child. The acknowledgement form can be signed by a birth parent and either an alleged genetic parent, a presumed parent, or a parent through assisted reproduction. So that means that an alleged genetic parent can sign the acknowledgement, as well as a presumed parent, meaning a spouse, or a parent through assisted reproduction. So they don't necessarily have to be a genetic parent or a spouse. The second, before you go to the next one, Sarah, the statements of acknowledgement are listed on page 2 of the acknowledgement. The statements explain to parents that by signing the form, they become a legal parent and that they should only sign the form if they're sure that they're a parent of the child. It also gives the parents their rights regarding rescission and challenge of the AOP. The instructions for completing the acknowledgement are on page 3 and 4 of the form. Forms can be notarized or witnessed, and the parents choose which option they prefer. It's possible that on the same form, one parent could choose to have their signature notarized while the other has their signature witnessed. A witness just witnesses the signature of the person signing the parentage form. A witness must be at least 18 years of age and not related by blood, marriage, or adoption to the individuals who are signing the parentage form. A notary confirms the identity of the person signing in front of them and completes the notary portions of the acknowledgement, including stamp and expiration date of their appointment. Completed forms can be dropped off at any DCS office, or parents can come to a DCS office to obtain and complete the acknowledgement form. DCS staff will provide written and oral information about the form and answer questions if the form is being completed in the office. DCS staff will notarize or witness signatures at no cost. DCS has policies that require identification to be provided when the AOP is witnessed or notarized. Any family can come to DCS for these services, and no DCS case is required for help with the acknowledgement. The acknowledgement can be signed at any time before or after the birth of the child, and it may be signed by minors. The acknowledgement is not valid until it is filed with the Department of Health Center for Health Statistics. There's no filing fee for the family if the acknowledgement is completed at the hospital within 5 days of the birth and submitted for filing through the hospital. Otherwise, there's an $18 filing fee. However, DCS will pay this fee for the family if the form is submitted through DCS. And again, DCS does not need to have an open case for the child. We'll submit an acknowledgement for any child that's born in the state of Washington. So I'm going to turn over to Jill to talk about the denial and rescission processes that are also mentioned on this slide.
Okay, before you go there, take a deep breath.
Yeah.
People are processing and thinking, and if we can slow down just a tad, it might help for people's processing at different rates here. But there is a question around if two parents sign an AOP, that they can have the filing fee waived. Is this true? Are there conditions, or do they have to have an open child support case?
So we will file the acknowledgement and pay the filing fee. So I don't know that there's a waiver process, but there's a process where there's no filing fee if it's submitted through the hospital when the child's born. So that's in the first few days after the birth of the child. There's no filing fee at that time. There is a filing fee after that. However, if people have problems paying the fee, they can submit the form to DCS. DCS will assist in filing the form with the Department of Health, and DCS will pay the filing fee for them. So it's not a waiver, but we will pay it on their behalf.
Okay, thanks. And then we always have questions about parents that are incarcerated. And so Kathy from DOC is asking, can the acknowledgement be completed or notarized in lieu of a DNA test for those that are incarcerated?
So in lieu of the DNA test is sort of a sticking point there, because DNA tests aren't required for the acknowledgement of parentage. Like we mentioned before, an alleged genetic parent isn't the only person who can sign in an acknowledgement. Acknowledgement can basically, as long as both parents agree that this is the only other parent and this is the person who's supposed to be the parent, they can sign the acknowledgement. I don't think it matters where it's signed. I think the only issue with an incarcerated parent would be finding a notary. If they have a notary available in the jail or the prison who's willing to notarize the form for them, then there's no reason why they can't sign it. The tricky part is probably getting both parents to sign the form. So you may have to do some coordination, getting the form from one parent to the other, for example. In some cases, DCS can assist with some of that. You can send the forms to DCS. We can sometimes facilitate having separate forms completed, one by the father, one by the mother. Those are, if you run into a situation like that, I would contact Jill and I at Division of Child Support, and we can assist people if you've got a situation where someone wants to sign an acknowledgement and they need some additional help facilitating that. Because I can't give you all the details on what would work in every single situation, but we do work with people to get those completed.
So, so there's always questions about who gets to claim who is a parent. And so this attendee is interested in a little bit more information about that. So who determines whether, like, an additional person that is claiming to be a parent is authentic. Can you talk a little bit about that process when there's not agreement, I guess, is the question.
Yeah, every situation is going to be different. The acknowledgement of parentage isn't intended for a situation where you've got two people who both agree. Um, I suppose there's situations where someone else, there's no authority who's adjudicating at the Department of Health whether or not some other person is out there. Aside from the fact that when you sign the form, uh, the fine print essentially says that you are the only people who could be a parent. If someone else is a parent, you shouldn't be using this form. Obviously, that doesn't mean people are incapable of signing things that uh, you know, I guess there's a certain amount of individual responsibility there. Uh, Jill was going to talk a little bit about the denial and rescission. We haven't quite got to that yet, but there are court processes. So if someone signs an acknowledgement, you've got two parents who sign an acknowledgement, and a third person is concerned that they really are a parent. At that point, that third person could go to the courts and petition for parentage. The acknowledgement of parentage being filed does not take away anyone's legal rights in court to assert that they were a parent or try to go to court to have their parental rights adjudicated. So
okay, thanks. That's helpful. And then I'm not sure, I still am not sure, Isaac, that I'm understanding your question about the relationship between parental acknowledgement and the um, immigration and citizenship question for people that are trying to gain citizenship in the US. Does that bring up anything for anybody? Or Isaac, do you have a more clarifying thought about what you're getting at? I'm not sure I'm following it.
And this is Jill. I'm going to jump in here. Party signing the acknowledgement of parentage does not need to be a citizen. We have forms that are notarized in other countries or witnessed in other countries because not always are both parents in the United States. So I'm not sure if that answers Isaac's question, but I've never seen an acknowledgement of parentage affect someone's citizenship in my experience.
Okay,
but I also
thanks.
do not deal specifically with the citizenship.
Thanks. That's helpful. And Isaac, if you have any follow-up thoughts, just let us know. Okay, so just lots of information, and wanted to give a pause and answer some of those really specific questions about this step in the process before we move on. And I think we're good to go. Thanks.
Okay, so this is Jill Schropp. I am the Parentage and Paternity Initiatives Manager with the Division of Child Support. I've worked with the Parentage and Paternity Initiatives program since, for I guess, the last 5 years, but with the Division of Child Support for over the last 23 years. So like Bridget, I have a lot of experience with the child support side and as well as parentage and paternity. So I'm going to discuss a couple of things. So we sometimes ask, what if someone wants to deny they are the parent? They may complete a denial of parentage form. The denial of parentage is a separate legal form that allows the person denying parentage to be discharged from their rights and duties as a parent. By filing this form with the Department of Health, the person denying parentage will not be listed on the birth certificate. This form must be filed with an acknowledgement of parentage form for the denial to be valid. A denial of parentage form must be submitted if the birth parent is currently married to or was married to another person at any time during their pregnancy, and the spouse or ex-spouse will not be the parent listed on the child's birth certificate. The spouse or ex-spouse would sign the denial of parentage. The denial can also be signed by a person who might be genetically related to the child, but will not be a parent listed on the child's birth certificate. The parents who complete the acknowledgement of parentage should indicate if someone will be denying parentage by marking the box at the top of the acknowledgement of parentage form. So there's a little box at the top of the acknowledgement that says, only check this box if another person will be denying parentage, and so that box would get checked. If the denial of parentage is submitted separately from the acknowledgement of parentage, meaning the presumed parent or genetic parent who's denying parentage is sending it to the Department of Health separate from the acknowledgement, there is an additional $18 fee required to file that form. There are also two processes to reverse changes made to a birth certificate by an acknowledgement or denial of parentage. The first is the rescission of parentage. An individual who signed an acknowledgement of parentage or denial of parentage may change their mind and rescind that parentage form. The rescission of parentage form must be completed and filed with the Department of Health on or before 60 days after the acknowledgement or denial was filed with the Department of Health or before the first court proceeding. The rescission of parentage is voluntary and does not require a court proceeding. An $18 filing fee is required to file the rescission of parentage. And once the rescission of parentage is filed, the child's birth record will change back to the prior record information that existed before the acknowledgement or denial of parentage form was filed. After that 60-day rescission period, the acknowledgement or denial may be challenged in court. A challenge to the acknowledgement of parentage or denial of parentage is permitted for limited reasons, including fraud, duress, or factual mistake, and must be made through the courts within 4 years of filing the form with the Department of Health. And when I'm referring to the Department of Health, that's the Department of Health Center for Health Statistics. So they like to call themselves the center, and we do appreciate the partnership we have with the Department of Health.
Okay, before you move on, a couple more clarifying questions about the acknowledgement of parentage. Can you talk a bit about the timing between the filing of the AOP and the reflection of that on the birth certificate?
Following your question, the acknowledgement, if it's completed at the hospital, when they file the birth record, they do that electronically in a computer system. So it sends the information about that child over to the Department of Health, and they can indicate that there is an acknowledgement of parentage that will be on its way, because the acknowledgement of parentage form must be the original form that's signed or witnessed. The Department of Health will not accept a copy of the acknowledgement. So it's called a parentage hold that they put on the birth record, and the birth record essentially waits until the Department of Health gets that acknowledgement and adds that second parent to the birth record. So when it comes, and then they can get a birth certificate naming both that names both parents. If the acknowledgement of parentage is submitted sometime after the child has left the hospital, I will say 35 plus days after that, then the birth record will list no father until that acknowledgement, and birth certificate will list no father until that acknowledgement of parentage is filed, and then they can request another birth certificate that lists the father named.
Thanks. I think you got at it. And then another related question around a father that was named on the birth certificate and then are removed from the birth certificate when it's registered. Does that happen? And if so, what's going on when that happens?
There shouldn't be no birth certificate like during the parentage hold period. Is that what we're getting at right after the child is born, or later?
Kelly, do you want to open your mic and
Sure.
clarify your question?
Sure. So when we're looking at birth certificates that are reflected as filed in the Department of Health system, it will have a father named, and then by the time it becomes registered, the father's name is removed. So I'm guessing those were acknowledgements of parentage that something didn't happen quite right on, or were.
So, and Kelly, what partner are you with?
I work for the Department of Children, Youth, and Family.
Okay, so yes, there would be a parentage hold on the record at that point in time. So usually it's right after baby's born, and the Department of Health has a parentage hold on the record, so it's showing as filed but not registered until that parentage hold is released. Usually when the parentage hold is released, it's about 35 days after the birth record was filed, allowing the hospital enough time to get the hard copy of the acknowledgement to the Department of Health, and the Department of Health to process that acknowledgement.
So if their name is removed, then that means something happened with getting that acknowledgement of parenting from the hospital to the Department of Health.
Likely the parents did not complete it. They indicated they would be completing an acknowledgement of parentage, but didn't actually complete it.
Okay, as long as I'm unmuted, can I just follow up with my second question?
Yeah, I was just going to say, go ahead and ask your next question.
Okay, so the birth certificate isn't automatically updated once an acknowledgement of parenting has been filed and received. That's a separate process that has to be requested.
So using different terms here, so the birth record is usually what, if you're from, you work for DCYF, you can see in the computer system, the birth record. The birth certificate is what is actually issued, the paper copy. So the birth record is automatically updated. The birth certificate, if people can have that paper copy, that it wouldn't be actually naming anybody if there's a parentage hold on the birth record. It wouldn't name a second parent until that birth is registered. But if there's been an acknowledgement filed after they received an original birth certificate, say the child was born at the hospital and 5 years later someone signs an acknowledgement that birth certificate that could have been issued, the paper copy during the child's first 5 years would not list a second parent, but then would list a new birth certificate issued after the acknowledgement of parentage was filed would list a second parent.
Okay, thank you. That's helpful.
Great, thank you. So there, you mentioned up to 4 years old, and there's a question about what happens after 4, and I'm guessing that that comes later in our conversation, but if not, does someone want to talk about that now? Oh, thanks, Bridget. You did it in chat, but can you do it out loud?
I did it in the chat. I was typing.
Go ahead and do it out loud.
So Jill mentioned the challenge with the 4-year limit to challenging the AOP. That's referencing the person who signed the AOP challenging their signature on the AOP in court. So you have 60 days to rescind it using a form with Department of Health. After that 60-day period, you have up to 4 years to challenge your signature to the AOP in court. So that isn't talking about a third party's rights to challenge in court or try to get parentage rights. It's only talking about the rescission of the AOP in court by the person who signed it, not by a third party.
Thanks. And so we're going to—
An additional clarification, an acknowledgement of parentage can be completed at any time during the child's life. So if I'm 30 and my father wants to be added to my birth certificate, they can do that now.
Thanks. That was my follow-up question. I'm not
30.
Okay, that was my follow-up question. So talk to us a little bit more about the relationship between DOC, the Department of Corrections, and this process. How is it changing? Is it changing? You know, how do we make this more accessible for fathers that are incarcerated? Jim Chambers is with us, and he's an advocate, a very strong advocate, and formerly incarcerated dad who went through struggles. And I'm trying to look at it in terms of the context, which, you know, Jim, you did that 20 years ago, I'm guessing, and the current. So that's one part of the question. And just, you know, how are we working to evolve that such that we are opening up opportunities for fathers that are incarcerated to have as much access as possible?
With the acknowledgement of parentage process specifically, an acknowledgement of parentage may be completed by someone who's incarcerated. Bridget mentioned the Department of or the Division of the Division of Child Support can facilitate a 2-part acknowledgement of parentage. So if the father is incarcerated or the mother is incarcerated, that person would be completed the form in prison and sending us the completed form while the other parent is completing the form, and also sending that into the Division of Child Support. The Division of Child Support can coordinate those 2 forms and submit those to the Department of Health for filing.
Fantastic. Missy, do you want to just open your mic and your comment/question, just say it out loud?
Sure. So I work in the Strength and Families program and we're working with incarcerated fathers inside prison. And I've seen quite a few dads being able to sign AOPs, acknowledgement of parentage or parenting or whatever the title is. But it's when the dads don't know if it's their child, but they think it might be their child. That's where we struggle. We have not been able to pretty much find unless the other parent is getting TANF, and then, they want to go after him for child support. So then the state will make sure that the DNA gets collected to see if that man is the father. Otherwise, our dads, we haven't found a way to establish parentage with genetic DNA testing from incarceration.
Yeah, and I think we're going to get to a couple options for that coming up here. Unfortunately, the next slide that I'm going to talk about is not one of those options, but maybe we can hold that thought.
Yeah, hold
thank
that
you.
thought, Missy, and bring it back up if we still haven't addressed it. And then there's interest from one of the dads in the room around Strength and Families. Could you just do the little quick short, the folks that are involved, what institutions you're in, and the role that you play with them?
Do you want me to do that, Anne?
Yeah, just really quickly, because
Okay.
I think the issue is, whether you are a resource to this individual or not would depend on what you say.
Yeah. So we are a parenting program for incarcerated fathers, a voluntary parenting program for incarcerated fathers based currently in 3 prisons on the west side, Stafford Creek, WCC, and Cedar Creek. And what our program is a series of classes, an evidence-based parenting class and a research-based communications and relationship class, and intensive case management that differs for each individual in the program. And then we support our dads as they go back out to 12 counties on the west side of the state.
Great. Thanks, Missy. Appreciate it. Okay, so let's go ahead and move on. I know there's a couple other questions in chat. I am capturing them. Let's make sure that we're not getting ahead of ourselves and let them go ahead and do their next section. And I'll bring it back up if we haven't touched on it.
So the Division of Child Support offers free voluntary genetic testing to unmarried parents who are interested in establishing paternity to help parents settle the question of the child's biological father early in the child's life and avoid any doubt about paternity. The main part of the voluntary paternity testing, we like to call it VPTP because Voluntary Paternity Testing Program is a mouthful, but the main part is the free genetic testing. The VPTP brochure is offered to an unmarried mother and possible father who do not sign an acknowledgement of parentage, most often at the hospital. This is a great program for parents who are not sure of paternity. The parents do not need to have an open child support case in order to participate in this program. The application is relatively simple with sections for the possible father's information, the mother's information, and the child's information. Both the mother and possible father need to sign the application since the process is voluntary. The parents complete the postage-paid authorization form and send it in to the Division of Child Support. There are really strict criteria for the program. All of the following must be true. The child was born in Washington State. The child is less than 2 years old. Both the mother and alleged father are currently at least 18 years old. The mother was not married at the time of the child's birth, and no other circumstances creating a presumption of parentage apply, as Bridget talked about earlier. No second parent is named on the birth certificate. Parentage has not already been acknowledged or established legally for the child by a court. The mother and alleged father have been offered an opportunity to sign an acknowledgement of parentage, but have declined to sign one. Both the mother and alleged father are considering whether to sign a voluntary acknowledgement of parentage, and both the mother and alleged father agree to participate in the program. Again, it's voluntary. There are other factors that would make parties not eligible for the program. If the mother or alleged father are incarcerated, we cannot complete the voluntary paternity testing because collection for testing is only available at a lab. If the child is not born, we cannot complete voluntary paternity testing. The child must be born before testing can occur through our program. If the child is still in the hospital, like in the NICU or PICU, we will wait until the child is released from the hospital to schedule the parties for testing. We cannot test minor parents, as those under age 18 would need to be assigned a guardian ad litem. So a little bit about the process. Once the voluntary paternity testing program application is received at the Division of Child Support headquarters, the Parentage and Paternity program contacts either the mother or alleged father, as there is a question on the authorization form that asks who we should contact. We interview them to make sure that they meet the criteria to participate in the program. After the interview is completed, genetic testing is scheduled through our contracted provider, LabCorp, and the parties are notified of their appointment date and time. They appear at the lab, which is the location nearest to the parties. They don't all have to go together. They can go separately if that's best for their circumstances. And they get tested by providing a cheek swab, also known as a buccal swab. The mother and alleged father received their report with the results directly from LabCorp 2 to 3 weeks after the samples are collected. If the alleged father is included as the biological father, we hope that the parties will complete an acknowledgement of parentage. The total process takes about 5 to 6 weeks, which differs from the court, which takes much longer. If the alleged father is excluded, meaning he's not the biological father, we can test other possible fathers. And over the last 5 years, about 25% of alleged fathers we tested were excluded. Voluntary paternity testing, genetic testing results are admissible in court as a chain of custody is maintained through the process. And the voluntary paternity testing program was added as part of the Parentage and Paternity program to help increase the percentage of children with parentage established and provide parents the opportunity to make sure they know who the father is, eliminating the questions that sometimes lead to rescission or challenge of an acknowledgement of parentage. If you are a community partner who would like a supply of voluntary paternity testing program brochures, please reach out to Bridget or I. Our contact information will be provided at the end of today's presentation. We just ask that you screen parties to make sure they qualify for the program. We hate for people to go through the effort of completing the authorization form if they do not qualify. We are also happy to screen parents and answer questions or provide other options and resources if you provide the voluntary paternity testing program phone line, which is 1-800-285-1892. When mother and man do not qualify for paternity testing through the voluntary paternity testing program, we do try to offer other available options depending on the circumstances. If there is no presumed, acknowledged, or court-ordered second parent on the child's birth certificate, either the mother or possible father may apply for services from the Division of Child Support. As Sarah will cover later, genetic testing may be completed as part of the court process to establish parentage. Sometimes there is a question of biological paternity, but legal parentage has been established. In those questions, parties may go to a lab on their own. Our contract is with LabCorp, but there are other labs across the state that do genetic testing, such as DNA Diagnostics, Fastest Labs, and others. A less expensive option is purchasing an over-the-counter paternity test. Over-the-counter paternity tests can be found in most drugstores, such as Rite Aid or Walgreens, but I've also seen them in grocery stores, usually in the family planning section near the condoms and pregnancy tests. The over-the-counter paternity tests follow the same science as an in-person lab, but the results do not hold up in court because there's no guarantee who provided the samples and no chain of custody. Next slide. The Division of Child Support Parentage and Paternity program maintains strong relationships with the state's birthing hospitals. We provide outreach and support to hospitals and midwives across the state. The state's Parentage and Paternity program must follow both federal and state law. Federal regulation requires states to establish a program for voluntary paternity establishment in cooperation with hospitals, state birth record agencies, and other entities designated by the state, and participating in the state's voluntary paternity establishment program. The hospital-based portion of the program must be operational in all private and public birthing hospitals statewide. So we reach out to a lot of facilities. State law requires hospitals and midwives to provide written and oral information and required forms furnished by DSHS and the state registrar to parents of a child about establishing parentage. It is also a federal requirement for birth providers to provide both oral and written information when offering the acknowledgement. There are several ways for birth providers to provide oral information. The acknowledgement of parentage video may be shown or shared. The video is available on the DSHS YouTube channel or on a DVD. We're also working on a QR code that will soon be available to make the AOP video more accessible. A toll-free phone number may be called for the parents to listen to a message about the acknowledgement of parentage. And another option would be for a hospital staff member to speak with parents about the acknowledgement. Written information should also be provided. In the acknowledgement of parentage statements of acknowledgements, which is page 2 of the acknowledgement of parentage, they can read that, or the established parentage for your child's sake brochure, which is published by DSHS DCS. Division of Child Support staff are also available to clarify information and answer any questions about parentage establishment. Hospitals and midwives are also eligible for reimbursement for their time to educate families about the parentage form. So when they're providing all that oral and written information, the Division of Child Support will reimburse them $20 per acknowledgement of parentage when the form is completed at the hospital and successfully filed at the Department of Health. All but a handful of the state's birthing hospitals request reimbursement through an electronic process. And finally, there are several timeframes that parents and providers should be aware of. Parents must return the acknowledgement of parentage form to the hospital within 5 days of birth for the hospital to submit that acknowledgement and the parents not to have to pay a filing fee. Hospitals must submit the acknowledgement within 10 days to the Department of Health. And as Bridget mentioned earlier, parents may submit the completed acknowledgement of parentage to the Department of Health with the $18 filing fee at any time. Or parents may submit the completed acknowledgement of parentage to the Division of Child Support at any time, and the Division of Child Support will pay the filing fee to the Department of Health. Now Sarah's going to cover the court order process to establish parentage, unless we want to stop and answer questions.
Before we go there, before we go there, there's still lots of questions, and I'm actually going to go back to the AOP for a minute because I've had a couple questions about time frames on that getting recorded in the birth record. Do you have a guesstimate, or is it different county by county, or what happens because some people are saying, gosh, it's taking like 3 to 4 months. What do you know about that?
So it depends on how the Department of Health receives that acknowledgement. So if the Department of Health receives the acknowledgement from the Division of Child Support, we have a contract with them, and they have to file that form pretty quickly, 10 days. So that's also an advantage of submitting the acknowledgement through the Division of Child Support. The Division of Child Support, again, we can help complete the form. We're here to help families. If the parties complete the acknowledgement and submit the acknowledgement to the Department of Health with the filing fee, that during the pandemic, there was a huge backlog at the Department of Health. They had staffing issues. They had people outsourced to assist with the pandemic. And so they ended up with a pretty big backlog. Right now, they have pretty much caught up, and their backlogs are much shorter than they used to be. So when people are talking about 5 to 6 months to get an acknowledgement filed, that would have been in the past. That's not the current situation with the Department of Health. Similarly, there was a little bit of a delay when parties completed the acknowledgement at the hospital and then the hospital submitted the acknowledgement to the Department of Health. It would take longer than what it's taking now, which is just a few weeks.
Okay, thanks. So some of this is historical, and
if
it's outside of that time frame now, maybe there are questions that could be asked in that particular process about how the data is getting moved forward. Fantastic. Okay, can you just take a moment and go back and talk about same-gendered parenting? So how does legal parentage establish with 2 moms and in vitro?
So that hits on what Bridget mentioned about parents who are parents through assisted reproduction. So they can complete the acknowledgement of parentage. the two moms.
Right, as long as they are in agreement. So no different.
Yes.
In other words, no different.
Correct.
And does
unless they're married, in which case
then it's a marital
presumption, correct?
Right. Okay. Hopefully that covered it, Margaret. If you have further questions, let us know. Okay. Wait a minute. One more question about the voluntary parentage establishment and schools. Are there any programs that help young parents, adolescent parents with, AOP, excuse me, filling that out? Or is there any support to schools like there is to hospitals for the voluntary parentage program?
I'm sorry, the voluntary paternity testing program? Are we talking about paternity testing?
The voluntary paternity testing program that offers hospitals reimbursement, that's part of the question. Are there any relationships with schools that help them support young parents through that process? Do you have a relationship with schools?
The Division of Child Support does have a relationship with schools through there are a few things. There's currently an economic mobility and responsible parenting grant that the Division of Child Support is working with many schools throughout the state to provide training and resources. Bridget probably can speak to that more. Bridget?
Hello. Yeah, I will say we don't have anything that's like super structured that's in every high school the way that we have something structured in every hospital around the state. We're required by law to have those relationships with the hospitals, with the birthing hospitals. We don't have anything that's that widespread or structured with schools. Division of Child Support does have school outreach. I've done some school outreach myself. I've been to multiple high schools in the past to talk to kids about parentage and paternity and other, child support issues. But I wouldn't say that there's something that's super structured that we're going around to every school. Admittedly, most high schools, I would say you're not dealing with a large population of kids that are parents. But, if you as an individual are aware of any kids that could use some assistance with that, please have them call us. We're happy to help anyone with the acknowledgement of parentage. So,
Great.
Yeah.
Thanks. Missy, you guys do free DNA testing for fathers that request it that are incarcerated, correct?
No, we do not. So
what I was
no, that's where our bottleneck is with some of our fathers. We're unable to get that actual DNA testing while they're inside. We've used like the some of the forms that DCS was showing earlier. I tried it from there with participants on my caseload, just like, hey, let's see if this works. Cause they were like, I really want to know if this child is my child,
Mm-hmm.
And I was never able to successfully, help anybody on my caseload get DNA testing while they're in regarding parentage.
And just as an aside, do you think that got captured in your work with the State of the State study about an opportunity to be exploring?
Oh, I do not think it got captured in our data there.
Could you make a note of that?
Yes, and Tara's on here too. Tara's on the call too.
Hi, Tara. Thank you. Yeah, if you guys could help us capture what the opportunity there is, because it sounds like that's something that's potentially, something we should be paying attention to.
Yeah, for sure. We do a lot of acknowledgement of parentage for dads that want to get on a birth certificate. Then they're going to apply for the Community Parenting Alternative Program, which is an electronic home monitoring program. So yeah, maybe they haven't been able to be on the birth certificate prior, but that's one way that we can work with our dads, as long as of course, like it was said, the other parent is in agreement.
Okay. Super. I'm glad I asked, because I thought from a prior conversation that I had heard that was happening regularly. So I'm really glad that we took that minute to explore that. And
I will say real quick, when there's TANF being given to parents in the community and there's a father attached, they will always come in and do DNA testing for that, because of course it's the state money that they're that it drives that. They want to have someone to hold liable at some point, but those are the only cases where I've seen it regularly happening.
Yeah, okay, that makes sense. Okay, we're going to move on. Amanda, I'm not sure I'm following your question because I'm not familiar with the term around good cause. So can you discuss what a father can do if a good cause has been filed to prevent paternity establishment? I'm guessing, Sarah, this is your section. Can you, do you want to shift gears and see if that's going to be covered in what you're going to talk about?
Sure, I can touch on good cause really quickly. So the good cause determination is a finding that the state won't proceed with the parentage case, but it doesn't stop a party from moving forward on their own to establish parentage. It simply means the prosecutor's office is unable to file a case because the finding has been made that it's not safe for the child or the mother in order for us to determine parentage. So we don't make that determination. So I don't know if the appeal from DCS would have any more information about it, but it doesn't stop you from having a parentage case. It only stops our office from handling it. So what I'm going to go over is legal parent by court order. And the court order may touch on some of the questions about incarcerated parties as well. And this may be an option that they can explore in order to get the genetic testing done and so forth. So just a few disclaimers. I practice in King County Superior Court, so I can only speak to the process in King County Superior Court. Each court is different. Each prosecutor's office is different. So how your case may be handled somewhere else will likely be a little bit different. We also only handle state filed cases. So if you choose to file a case on your own, your case may proceed a little bit differently. So a couple of the questions that came up in the chat, for example, somebody asked about undoing the acknowledgement of parentage. That's something our office doesn't handle. We can only handle cases that are allowed by statute, and we can't do that. But that may be something you can proceed with a private attorney on or pro se in trying to undo the acknowledgement. And the statute does give timelines and requirements, but that's something you can certainly look into. It's just our office wouldn't be able to handle that. There was also a question about terminating legal rights of absent parents. That's also something we don't do. Terminating rights is a very high bar. So we don't handle cases that are terminating anybody's rights for being absent or reasons such as that. So those are a couple of things our office doesn't handle, but you can look into. And the other thing to remember is that each case is different. So the facts of your case or your friend's case are going to dictate how a case moves. And this is going to be a fairly general overview of how the court process works on state cases. So legal parents can be by court order a few ways, and two of these I'm just going to point out so that you're aware of them, and we're going to focus mostly on genetic parents. So as was mentioned, in order to be a legal parent by court order, we need a genetic test and the chain of custody, which is the proof that this person submitted genetic material. And that's how most of our cases will go through the court process. But two other ways that the court can recognize a parent is a holding out presumed parent, meaning you're living with the child and openly hold them out as your own, or a de facto parent, somebody who has acted as a parent in other ways complicit with the statute. But the bottom two aren't the two we're going to focus on today. So how do cases get to the prosecutor's office? We can get cases a number of ways. One way that I think most people think of and generally think is the way we get all of our cases are TANF referrals. So DCS refers a case to us because parentage isn't established and the child's receiving TANF. And yes, we do get those. And we move forward on those to establish parentage and child support and back support if appropriate. But the other one that we're really trying to make sure people know is available are non-assistance requests for services. And this is where I think incarcerated fathers may have a way to get parentage established. As Bridget mentioned, the court process is a little slow and it can be expensive. I can't say that our process isn't slow, but it's free. So we get rid of the expensive part. And any parent, alleged parent, person with physical custody, can request services through the Division of Child Support. So even an incarcerated father or incarcerated person who believes they're a father can request services through the Division of Child Support. There's no income limits. We just have to have jurisdiction and a request for services. And just to put a quick plug in here, not only do we do parentage, we also will do child support reviews and enforcement cases at no cost to the parties. We don't represent any party, but it's free. We handle the filing, we handle the service, we handle most of the logistics. And I'll go over genetic tests in a little bit, but we do handle the genetic testing, and we can get a court order for testing to be done in a jail or in a prison. The other place that we can come in is on dependency cases. Now, these used to be a little easier because they used to automatically get referred to us, but now they're not. But if you believe you're the father of a child and a dependency case has already started, you can make a request for services to the Division of Child Support, and we can establish parentage. It's a little more complicated because we have to get a court order that allows us to get involved in the case, but it may be helpful if, say, they're trying to figure out placement of the child. Having a legal second parent may allow other people to be a potential placement for the child, or down the road when you're looking at where's a child going to be placed. So that's another area that we can help in, that somebody can make a request for services. And remember, it doesn't matter who asks us for the services. We proceed in the case the same way. We don't represent who asked first. We don't only help a mother or alleged fathers. We will take a case from any parent, an alleged parent, that we can establish parentage on. As was mentioned, other than good cause cases, once good cause is found, then we can't become involved in it. But I think this would be a great way, Elaine, for people that are incarcerated to possibly establish parentage. So starting with the court process, there are a few things we need to file a parentage case. First, we need the request to DCS asking that we start the case from somebody. The other thing we need is a sworn statement showing a reasonable probability that the alleged parent is a biological parent. And we will mail we have great paralegals in our office that will mail out the forms to you to fill out. We will mail you out the declarations that you need so you can fill in the information. We will put it together in the packet. We will mail it to wherever you're at and get the information that we need in order to file the case. And that can come from either parent. The second thing we need is service. And this is one area that sometimes we get stopped because the bar for parentage is personal service. And our goal is always to give people actual notice. We don't want to move forward on a parentage case that somebody doesn't know is happening. And that's why the law is high in terms of the service we need. So sometimes this can be a barrier for us if we can't find the other parent, if we're not able to serve the other parent, they don't have a good address. The pandemic, I think, has made it even harder with so many people that are unhoused or their housing moves a lot. That can make it difficult to perfect service. So service is one area where our cases can sometimes get stalled, but we will use all the resources we have in order to serve parties. I was trying to go through the chat really quick, Anne, but I'll let me know if there's something I should stop for.
I am watching it.
That will get me stalled.
I am watching it.
I was going to turn over there really quick. So going to genetic testing, which came up for, I know, incarcerated parties and others. Genetic testing with a chain of custody is expensive, and we will do it and we cover the cost for it. We will schedule the mother, the child, and the alleged biological parent. We only need the alleged parent and the child for valid results, but we generally prefer to test all three. We want testing because it ensures finality. We try to finalize all of our cases with genetic testing. We also, it's necessary if there are multiple people alleged to possibly be the father. So our preference is to do everything we can to complete genetic testing on all of our cases. What do we need? We need results that are admissible to prove parentage. So the test that you did off Amazon or Rite Aid is probably right. It's probably accurate. It's just not admissible in court. And what we need is that chain of custody that you keep hearing us say, which shows this person submitted their sample, this child submitted his or her sample, this person submitted their sample, and we can say who the parents are biologically. So it's a little more complicated process, and why we use LabCorp, because they're able to give us a chain of custody for court. And again, that's something we will take care of the cost for. We cannot do genetic tests unless we have a case. So you can't just come to the prosecutor and say, I just want genetic testing done. We have to file the case. We will schedule the appointment for you. And then we mail notice, we email notice, we call, we do everything we can to get people in for their genetic tests. Where we do them, this is where we can do them in prisons. We can do them in jail. We have to get a court order to allow the person to go in to do the test, but it can be done. We used to do them in our office, and in COVID, we moved to LabCorp, which I think in some ways has been better because it allows the testing to be done at many different locations around the state. And as was mentioned, even if we have jurisdiction, somebody out of the state, we can schedule their testing. We'll reschedule it to work around your work schedule. If you'd rather have your test done by your job, we can have it done by your job. If you want it by your house, we can do it by your house. Whereas before, they were pretty much all done in Seattle or Kent at the courthouses. I think this does allow for a lot more flexibility for parties in terms of not having to interrupt their workday and so forth.
Hey, Sarah, before you go on, can you go back to service for a minute? I know you said in person, but there's a question in the chat about text as a viable method for service. And it sounds like you're saying no.
We can't do initial service by text. We have to prove that we gave somebody the documents, and there are a few ways to do that, proving it's your address. After the case has been started, we now can email documents to parties, and there's now a form that allows you to step service by email, but the initial starting of the case, we need to get it to a person. Now, we do have people that request services or parties, and they don't have good mailing addresses, and they come in and pick up the packet. We could email it to you and you sign a document that says, I accept service and I acknowledge I received the packet. So we don't have the technology to text stuff yet, but we will do whatever we can to help get you the information. If you want to go to the Seattle courthouse and pick it up, because that's more convenient for you, you can do that. Like I said, we can email it and you just need to sign and show, yes, I received it, but we can't text it.
Okay, thanks for clarifying. Yeah.
So once we have completed genetic testing, we move forward to how is the case going to resolve. And there are a few ways our cases generally resolve. The most common is summary judgment, and that's what I'm going to go over in the next slide. Sometimes we have to dismiss the case. Generally, that's because the genetic test shows that the person that was the alleged parent isn't the parent. So we are going to dismiss that case. Or sometimes we just can't complete genetic tests at all. If we have a case where we have exhausted all of our resources in an effort to complete genetic tests and we just can't, then we may have to dismiss the case in that way. Default, we don't like to default cases, and we try to do it as rarely as possible, but the law does allow, if somebody has been properly served and we have a statement from the mother saying that there are no other possible fathers, and that alleged father has not responded in any way, then you can be defaulted and named as the father. So a key here is if you get paperwork that says you're the father, if you get paperwork from our office, Division of Child Support, wherever it comes from, respond, participate. Say it's not me. I don't believe I'm the father. I don't know I'm the father. I want a genetic test. But the law does allow for defaults if you simply don't respond. Or the case can go to trial. Most of our cases don't go to trial on the issue of, are you the legal parent, they may go to trial on parenting plan and or other things. But once we have genetic tests, that generally answers the question. So summary judgment. Once genetic testing confirms, yes, there's a 99.99% this person is the parent, we will file a motion for summary judgment to make the alleged father not just the biological parent, but the legal parent with all the rights and responsibilities that come with being a legal parent. What we will do is we mail those results to the parties with a request for financial and other information. Because what we're looking for is naming the parent. As you can see, we're going to ask the court to name the legal parents. We're going to ask the court to address child support. Sometimes that gets reserved back to DCS. We're going to ask the court to look at back support, to order back support if it's appropriate. And we can ask the court to address other issues. So this is where the responding is appropriate, because here's where the doors open for either parent to ask for a parenting plan or to ask to change the child's name. Maybe you want the child to have your last name. We've already served the parties. We've already filed the case. All we need is someone to come in and say, yes, I want a parenting plan. And that door is open for you to walk right through and address those issues, assuming we have jurisdiction. And we're not going over those small details, but if we have jurisdiction, you have the right to come in and ask for a parenting plan. In terms of, I'm going to go back up to child support. This is another area where it's really important that people participate. People often think the court and the prosecutor's office knows how much you make, knows if you have other children, knows your financial situation. We don't. We do not have FBI type data at the prosecutor's office that we know everything happening. We are doing our absolute best to make an accurate child support calculation. We don't want the highest order possible. We don't want the lowest order possible. We want a fair and reasonable order based on your financial situation and the other parent's financial situation. But we can only know that if you participate. Because there are some things a court can take into consideration, like if you have other children, you need to tell us. Are you paying into retirement? You need to tell us. Are you going to be adding the child to health insurance maybe, and there'll be a fee for that? We need to know. So this is another area it's extremely important to participate. Back support, maybe you've been supporting this child. Even though you weren't the legal parent, we don't know that. So we need parties to participate and say, oh no, I've been giving support in this way. Here's what I've been doing. I want the court to take that into consideration in terms of ordering back support or no back support. We can't make that argument for you. We don't know that information, but this is your opportunity to tell the court, hey, here's what's actually going on, and I want the court to consider that. We're going to mail the parties the motion and responsive documents at least 30 days before the hearing. Our goal is for parties to have an opportunity to be heard. And even if somebody's incarcerated, we've worked with counselors in jail for them to appear by phone. I don't think I've had anyone Zoom in from jail. I think they've always been by phone. But if they can Zoom in, they can Zoom in. Hearings are in person and by Zoom. So if they're in, say, the RJC, they can be transported over for their hearing potentially. But if they're housed somewhere else, they can call in. We try to take those cases first because we know the counselors are on strict timelines. But any request that we receive from an incarcerated person to participate, we will do what we can do to make sure that they have the right to be heard. But they can respond in writing as long as they get the documents to us. This isn't just incarcerated parties. This is any party. You mail it to us. We do the filing for you. We get working papers out to the judges to make sure that the courts have your paperwork, because this is a complicated process. It's not easy to get what you need to the court, to the other parties, to prove that you got it to the other parties. We'll do all of that for you, and then you'll have a chance to be heard in court. A few things we can't do. We can't give legal advice. We can't fill out forms for you. We can't tell you how to fill them out, but we can process them once you do. We need things in writing ahead of time. So oftentimes parties think telling us that we're important. We're not. It's the judge that needs to have it. We don't wear black robes. We don't get to make final decisions. But you get it in writing, we will get it to the court. And then any issues that don't get resolved, such as the name change or parenting plan, those things can go to trial. And then you have another opportunity in front of a judge to provide evidence, to provide witnesses if you need to provide whatever else you want the court to know about your situation. So that's how it goes with the court processes on state filed cases. And what I want people to know is, one, especially based on the questions, we will take as many cases as we can. If we have the authority to handle it, we will move forward the best we can. And it can be a father, a mother, DCS because the child's on TANF. We handle all of those cases in a very similar manner moving forward. There's no cost to anybody. There's no income requirements. You can be incarcerated. We will do everything we can to get your day in court and to finalize parentage.
Just a quick insert here. Questions about TANF. Temporary assistance to needy families is a cash assistance program at a certain level of poverty. Individuals can qualify for that cash assistance. How it relates to child support is that when TANF is in place, a certain portion of child support that's collected goes back to the state, not to the custodial parent. We are trying to change that in this state. There is a percentage that goes through now, and I'm going to get in trouble here, Bridget and Jill, but I think we're at 25%. Help me confirm that, if you would. The pass-through? 50, thank you. So, and there have been many discussions about full pass-through. There are only a couple states that do that. But as a policy, that is definitely something that Washington has been pursuing for quite a while. I just wanted to clarify that because that came up in the questions. Hey, Dieter, could you pop the evaluation in the chat? So thank you to DOC for putting the legal information line in the chat. So for those of you who work with currently incarcerated parents, it looks like there is a resource that you can access for those folks if they have legal questions, and Parentage obviously being one of those. So thank you for posting that. Appreciate that. And Dieter is putting a survey in the chat right now that we would greatly appreciate your feedback on this session and future sessions that you would like to see. We do read these, we do value these, so we'd love to be able to send you like a chocolate bar through the chat to say thank you. But what we're going to do is go with your goodwill instead, that you're going to take a couple moments to fill that out before we leave. And he does leave it open. I think you leave it open for like a day, right, Dieter? So they could do it later.
It stays open for several days. So yeah, please take some time.
And I just see, I'm trying to go through the chat really quickly. I see a question about an alleged father is deceased. Can the mother ask for them to be tested? We actually do handle those. We can't file a case, so you won't have a court order that says this person is the legal father. But we do, we can handle some cases and do genetic testing, which is sometimes enough for like Social Security benefits or other things. So if you have a case where the alleged father is deceased and his family is willing to participate, then we may be able to do testing in some of those cases, but we can't obtain a court order. And then there was about fees for testing. I'm not aware of any offices that charge for testing.
Thank you.
We don't. And I'm not aware of any that do, but I only work for King County, so I can't. Don't quote me and say King County said you can't, but I don't believe anybody does.
Yes. This is Serena Hart from DCS. So no county charges initially. The state forwards the cost always on state-initiated paternity cases, but at the end, if they're if the person is established as the parent and they have the resources to pay, some counties do ask for the genetic test to be reimbursed to the state.
Thanks, Serena. I appreciate that. So Jim, you know, your point around whether folks know about that call line or how to access that. I mean, and that's the point of these provider learning series, right? You all are allies for your clients, your relationships that you have with family members to help people navigate these hard to navigate systems. So that's why we're doing what we're doing, so that you have as much information as you can to help support those individuals. And then secondly, what Missy and I were just talking about a moment ago is, we're looking now at the state of Washington in how we support fathers. And we want to capture those things where we think there are bright spots and hot spots for things to work and for things that are challenging to try and change them. And it feels like this is one of those places where it would be really good to get that up on the radar screen. So a couple last questions here before we have final comments from our folks. Talking about dependency with concurrent jurisdiction, I'm assuming hold on, I got lost in your question. If it is a dependency case and the concurrent jurisdiction is not granted or agreed upon, will you still proceed with a request from an alleged father?
We would need the concurrent jurisdiction, but with the request, we will work with you to get the paperwork we need in order to move forward on a dependency case.
Thanks. Lots of alphabet soup in that text there, Ms. Cunningham. We love our shortcuts in the world of human services. Well, probably every discipline does that. I think we have hit all of the questions. There were a couple early on that I knew, Sarah, you were going to cover. Please, yeah, DOC soup. Everybody has soup. So if your question wasn't answered, just take a moment and pop it back into chat. But I think we've hit the ones that I have seen. Somebody commented in the Q&A, why do we think there are so many people on this call? And I just have to say, look at the complexity of what we just covered. There is just still a lot of question and a lot of confusion around establishing parentage. And we have fairly high rates of non-marital births in our population. That means that we have lots of parents, dads that are in a position to establish that in another way. And so these are really important conversations and super important for us to have these conversations regularly within your sphere of influence. Joe is talking about a podcast. Joe, I don't know you, but if you want to start a podcast, we'd be happy to feed you with people to talk to around so many different topics, because I think there's just a lot of opportunity for us to improve these systems for families so that we are making sure that all parents get to be in the lives of their children and that all children have access to their parents. And Dad's Move. Oh, you're a Dad's Move. I didn't know you guys had a podcast. That's exciting. Yeah, put a link to your post in here. And then local jurisdictions, I guess you just call the courts. I assume that there's not a one-stop shop to get to different counties. Is that correct for the prosecutor's offices? And then who would you ask for? So how do you find it? And then who would you ask for, Sarah, in the local counties for the prosecutors that do what you do?
I would, for some of the smaller counties, you're going to look up the prosecutor's offices, and their family support division is who generally handles these cases. But if you go through the Division of Child Support, they are great about filtering the cases out to the appropriate prosecutor's office. So your first step generally is going to be the Division of Child Support, do the request for services, and they will get that to the correct prosecutor's office based on where the parties live.
And I'm assuming, I haven't seen anybody, although I can't look at 180 names here while I'm doing this, but I'm assuming that Alternative Solutions is also a place that could help people navigate that.
Sure. And yeah. I mean, they'll certainly know where to send the case to.
Yeah,
If that would
absolutely.
be somebody that already has a support order maybe and has another child, absolutely.
Yeah. All right. So if you all could, if you just have a last comment that you would like to share with people about navigating this process, the importance of the process, what you would want providers to know or to take away from what we talked about today. And Sarah, could you start us off?
Sure. Thank you, everybody, for coming today. And thank you, Anne and Dieter, for inviting us to participate. What I would hope people take from this are a few things. One, we acknowledge these are important issues. These are people's children. This involves money. This involves things that are the most important to us. And they're complicated. And we're here to help in as many cases as we can. And we are not here to only help mothers. We're not here to only help alleged fathers. We are here to help both parents equally and help establish parentage. So if you have a case that you think we can help with, contact the Division of Child Support, do the request for services, and send it in. And if we can help, we absolutely will. It's free. There's no income requirements, and we will take as many cases as qualify and we can move forward on. And the key to us moving forward is often participation. So if you get paperwork from us, respond, call us, ask what it is, because we are going to do everything we can to make sure you have an opportunity to be heard and to finalize cases and determine parentage. So please participate. Please reach out if you think we can help you on a case.
Thank you so much for joining us. Bridget, do you want to go next? Any last thoughts, Bridget? We may have lost her. Jill, do you want to wrap us up here?
Yeah, and I will just say Bridget's had some power issues today, so maybe we did lose her. I do want to echo Sarah's thoughts that we thank you all for allowing us to present today, and let you know that the Division of Child Support and the Parentage and Paternity Initiatives Program, we are here to support families and providers with specifically with administrative parentage establishment, so questions about acknowledgments, the voluntary paternity testing program. We want to be able to help and support you as you support families. Establishing legal parentage is very important for all children, and we know that not everybody's situation is the same. So there may be those situations that we have not covered today. But we can try to help with that. Bridget and I are both available to answer questions, provide options, resources, and materials. So please reach out.
Thank you so much. As we said at the outset of this conversation, this was the largest registration that we'd had in our provider learning series. And we can see after having spent an hour and a half in this conversation why, and that we could do this again and learn much more each time we do it. So we so appreciate your willingness to jump into this conversation with us, the resources that you provide, and the great work that is happening. We know there are still things that we need to focus on. We know that there are opportunities to pursue. And so we just encourage you as allies to fathers and families and or family members to stay in conversation around this and help us create that collective action that will move the dial on some of these sticking points for families that make it really tough sometimes for particularly fathers to participate in the lives of their kiddos. So thanks for joining us. And Dieter, our next one is third week of February. We're running into a two-part series on men in the lives of families with young children with three of our star presenters. So we're excited about that one. And I'm sure Dieter's got the actual registration he can share with you, or it will go live soon. And so stay tuned, come back. We're excited that you're part of this conversation with us. Have a good afternoon. Thanks all. Thanks, Dieter, for putting it in the chat.